My name is Izzy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Tonight's webinar, we're going to be discussing division of property in a Colorado divorce, and we are incredibly grateful that you were all able to attend. As a member of the Colorado community for over 25 years, the Harris Law Firm has always tried to give back. For over 30 years, the Harris Law Firm has always tried to give back to our community. This and future webinars are a free service that we provide. Now, I would like to introduce our presenter today, Katy Ellis. Katy is a partner at the Harris Law Firm, and she's been practicing law since 2007. She clerked for the Colorado Court of Appeals she clerked for the Colorado Court of Appeals for 1 year before moving to private practice in the areas of family law and estate planning. She's involved in the American Inns of Court, the Colorado Bar Association, the Colorado Women's Bar Association, and the Colorado chapter of the Association of Family and Conciliation Courts. Katy practices as a trial attorney, an appellate attorney, and a transactional attorney. All right, Katy, without further ado, I'll turn it over to you.
Thanks, Izzy. So yeah, as Izzy said, we are so grateful that all of you have chosen to take some time this evening to learn a little bit about the division of property in a Colorado divorce case. A couple of disclaimers from the beginning. Number one, this webinar is not designed to give you particularized legal advice about whatever might be happening in your case. We are going to do our best to give you some general concepts, help you understand sort of the language that we use in these family law cases and the general guidelines for how property division is addressed. But if you are in the middle of a divorce or contemplating a divorce and have specific questions about an asset in your case or a debt, please reach out and consult with an attorney, either at our firm or somewhere else. There are lots of family law attorneys in Colorado, but make sure you're getting legal advice that's actually tailored to what's going on in your situation. And obviously also extends to those of you who are current clients of one of the attorneys here at the firm. If the general answer that I'm providing here seems to be conflicting in some way with what you have been discussing with your individual attorney, certainly you can mention to them this webinar and they can loop me in and we can have a conversation about whether that attorney and I disagree about the way this works in general or if it's just because of something going on in your particular case. But please bear that in mind as we're going through this. One other disclaimer is I will use the word divorce throughout this webinar because it's just easier than spelling out longer options and covering everything that this would apply to. But typically when we're talking about divorce in Colorado, we also mean a dissolution of marriage, which is the expression we use in Colorado to mean a divorce. The same guidelines about property division also apply to legal separations. So if you're considering a legal separation or are in that process instead of a divorce or a dissolution of marriage, functionally the standards are the same for all three of those things. And to be clear, a divorce and a dissolution of marriage are exactly the same thing. So, all right. We will this evening talk a little bit on what the law is in Colorado about property division. We'll give some examples and some practical tips, and then we'll leave some space at the end for people to ask questions. I know a few people have already sent questions in to Izzy, and we have those ready and waiting to be answered when we're done with all of this. But if you think of others while this is going on, like Izzy said, please pop those in so that we can get to them if we have time at the end. All right, so the purpose of doing this overview of the law is not to turn all of you into lawyers, but hopefully to make the process seem a little bit less confusing and therefore give you a little bit less stress. That's the objective. So that's what we're hoping for. In terms of what we're actually going to cover, the steps that you have to go through here that are relevant. One of the first things that happens in a divorce case or a legal separation or any of those actions is that each spouse has an obligation to fully disclose all of their assets, debts, and income to the other spouse. After they go through those initial disclosures, each spouse also has an opportunity to serve discovery, which is a chance to get additional information from their other spouse or from third parties that would be relevant to dealing with all these property division issues. When the court gets all of this information, if you're not able to settle things yourselves and have to go in front of a judge, the first step the court has to go through is identifying all of the property that exists and then separating out which property is marital, meaning it belongs to the marriage and is fair game to divide between the parties, and which property is separate property of one of the parties, which would be property that is pulled out of the marital estate and the court doesn't have the right or the jurisdiction to divide it. Once the court has come up with those distinctions, it also has to value each asset and debt in the marital estate. Then it has to divide the marital estate on an equitable basis. And then after it's gone through all of that, the court can determine whether there should be an award of spousal maintenance, which is what Colorado uses to mean alimony, and whether to order one of the parties to pay attorney's fees or contribute to some of the attorney's fees for the other party. We're going to unpack all of those things as we go through the webinar tonight, because I know that's a lot of information in one little slide. But just to give you a general understanding of the sort of steps that happen in the divorce case, that's what we're generally talking about. So that first step is gathering information. In order to equitably divide the marital estate, we have to know what we're dividing, right? It's not enough to go in and say we each get half of everything. You have to identify what it is you're splitting up. In family law cases, each party has a heightened obligation to the other party in the case. So if you're involved in a civil lawsuit, for example, you don't necessarily owe the other party much of anything other than an obligation not to lie, right? In family law cases, you actually have an affirmative obligation to be forthcoming with information about your finances and anything else that's relevant to what the court has to decide. As part of that, the first step are these mandatory disclosures. So Colorado Rule of Civil Procedure 16.2 includes a list and instructions about exactly which documents have to be produced without anyone even asking. So if you're in the process of divorce, whether you're the one who filed or you're the one who was served with papers, and you are going to need to pull together your tax returns for the last 3 years. I think it's 3 months of recent pay stubs, the most recent statement for every bank account you're on, retirement account you're on, credit card or other debt that you're on. So you're really kind of producing a lot of information right up front. There's some other documents that are part of the mandatory disclosures as well. Those are all contained in a form that is available online. We'll have the link for that later in the presentation, called 35.1. In addition to those mandatory disclosure documents, each party has to prepare something called a sworn financial statement. And the purpose of the sworn financial statement is to give the judge and each party a sort of snapshot overview of your assets, your debts, and your income and expenses. So the first half of the form focuses on income and expenses. You list income from all sources. So whether that's active income because of employment, passive income that you're getting from investments, regular gifts that you're getting from people, anything that might be considered income. If you're working 3 jobs, the income from all of them goes in the sworn financial statement. Then you also disclose all of your expenses. That includes mandatory and voluntary deductions from your paycheck, like taxes, what you might be contributing to a retirement account, the cost of health insurance if you're paying that through your employer. It also includes everything else you spend your money on. This part of the process can be kind of tedious because it really is trying to account for where all of your money goes every month. And a lot of the places our money goes are not necessarily expenses we have every month, right? One of the things you think about is like vehicle maintenance. Well, most of us don't break down our payments for things like getting the brakes repaired and getting an oil change into monthly payments, right? For most people, it's like, oh, this month I owe my mechanic $1,000 for something I didn't even know was wrong. That's great. So what you're trying to do though is kind of break that out. If it's, you paid $1,200 this month, that's $100 a month that you have to put on your sworn financial statement. Once you get through income and expenses, you then list all of the assets and all of the debts, including the ones that you believe are separate property. We'll talk again a little bit later about the difference between marital and separate property, but on the sworn financial statement, you're disclosing all of it because remember, part of what the court has to do is make a decision or make a finding that this property is marital property or separate property, and they can't do that if they don't even know the property exists. After you've gone through the mandatory disclosures process, each of you can also issue discovery to get more information, basically. And in our cases, discovery has sort of 3 different characters. One is something called a request for production of documents. That is something you serve on the other party, where you're asking them, as the name suggests, to produce certain documents. There are some pattern requests that you're allowed to ask in all cases. Those are things like, I want all of your bank statements for the last 3 years. all of your credit card statements for the last 2 years. So there's some of those documents that are just automatic, that are in the list already. And then you also get 10 questions that you can craft that are appropriate for your case, right? So if you want someone to produce all of the documents related to some investment scheme that they were involved in last year, right? You might have that as an independent request for production of documents. But understand that, as the name suggests, all you get to ask for there are physical documents. You don't get to ask them to explain anything. You don't get to force them to create something that doesn't exist. So if you want to have an accounting for everything that occurred with this investment scheme, you can ask for whatever documents they have, but you can't ask them to create a ledger. That's a different thing. And that leads into the second set of things you're allowed to ask, which are interrogatories. Those are questions that you're giving the other party that they have to answer in writing under oath. The interrogatories, just like the request for production, also have a split between what we call pattern interrogatories that are pre-drafted questions and 10 additional non-pattern ones that you get to create yourselves. Apologize. So in the interrogatories, the pattern requests, for example, include things like, if you are employed, provide all of this information about your current employer. So it's like, when did you start? What is your title? What's your salary? Do you have any other, benefits or reimbursements that you get as part of your job? Do you get bonuses and commissions? When's your next performance review? All that kind of stuff. And then again, you get to ask additional interrogatories yourselves. So if you wanted to know the names of everybody who was involved in the investment scheme that your partner was involved in last year, that would be an interrogatory you could ask. The third type of discovery are subpoenas that get issued to third parties. In our cases, that can include anything from subpoenaing a bank if you want records that go back even farther than 3 years. You could be, or if you don't know what accounts exist, right? You may, if you don't trust the other party, you may want to say, well, I know that they bank at First Bank, so I'm going to send a subpoena to First Bank that says, send me every statement for any accounts that this person holds at your bank or has held in the last 5 years, right? So that would be an example of a third party subpoena. And there's a lot of nuance with regards to the third party subpoenas, who you're allowed to subpoena, what you're allowed to ask for. But again, since this is a very general webinar, that should give you at least some idea what the ways that we gather information. All right, once we have all the information, we have to determine what is marital property. So generally speaking, in Colorado, marital property is all of the property that either of you acquires while you are legally married to each other. That means from the date you got married, or the date that you agree your common law marriage began, or the date a court says that your common law marriage began, until the day the decree of dissolution enters. That's not the same as the day someone files for divorce. So if you file for divorce and it takes 6 months or a year to get divorced, anything that you acquire while the case is pending is still technically marital property. The exceptions are gifts, right? If you receive a gift from someone, that is typically separate property unless you presumptively gift it to the marriage then by titling it in your partner's name or investing it in a joint asset or putting it in a jointly titled account. So for example, if somebody gives you a gift of, let's just say, $500, and you put that in an account in your own name that you open up just to hold on to that money, that is going to be considered separate property, almost certainly. If, however, you take that $500 and put it in your joint bank account with your spouse, it's not separate property anymore. So that's something to think about, as you're moving forward. Similar to gifts, inheritances works exactly the same way. If you inherit money and you keep it separate from your marital property or from your spouse's property, it will continue to be your separate property. And then similarly, let's say that the asset you inherit is not money, but it's like a house in the mountains, right? You inherit a rental property, or you inherit your grandmother's condo or something. If you inherit a piece of real estate and you decide, I don't want this real estate anymore, I'm going to sell it, or I'm going to, sell it and buy a different piece of property. Whatever you get in exchange for that separate properties is also separate property. So if you sell grandma's condo and invest that money in a savings bond, the savings bond is still separate property. And then lastly, marital property can certainly, the definition of that can be changed if you and your partner have a marital agreement, what we used to call a prenuptial agreement or a postnuptial agreement. If you've executed a marital agreement that says some of these things I've just described are also marital property, or certain assets that we haven't addressed are going to be separate property, even though they were acquired during the marriage, that's another way that property can become separate or marital in any given case. It's also important to know that if you have these separate property items, like let's say you inherit $1 million from your favorite uncle, the $1 million you inherited would be your separate property if you keep it titled separately, but the increase in value of that property is marital. So if you leave that $1 million sitting in a bank account and over 10 years it earns 72 cents in interest, because that feels like that's what the going rate is right now, those 72 cents are going to be marital property that have to be divided between the two of you. But the underlying gift or inheritance stays your separate property. This can get obviously very murky when you're dealing with things like real estate and all of that. So it's one of the reasons lawyers have jobs, right? Is to help people navigate how to calculate all of this and figure out what's marital and what's separate. Okay, one of the most common misconceptions that people come to lawyers with when they're going through divorces is the idea that I don't own our house because it's in my spouse's name, or because the car is in my name, it's mine and it doesn't belong to my husband or my wife, and it's not their property and it doesn't belong to the marriage because I bought it with money that I made at my job and it's in my name. Title does not determine ownership for purposes of divorce. You're absolutely correct that title would determine ownership for purposes of the rest of the world. So if the house you're living in is only titled in your spouse's name, your spouse is probably legally able to sell the house without your consent or even knowledge, which is scary. But if you were getting divorced, the fact that the house is only in one spouse's name does not mean it doesn't belong to the marriage. To determine whether it belongs to the marriage, you're going to have to look at things like, when was it purchased? Right? Was it acquired as a gift or an inheritance? But if it was something that your spouse bought while you were married using their employment income during the marriage, it's going to be a marital asset. Already addressed the fact that increase in separate property, increase in the value is marital. And then lastly, the value of the property items is going to be calculated at the time of the final decree. So again, if somebody files for divorce tomorrow and the divorce itself doesn't happen until December, the valuation for everything should be as close to that final decree date as possible. So you're going to be looking at the value of those assets and debts in December, not the value right now. If the market takes a crazy swing and your retirement account crashes or goes way up, it does not matter what it was worth when you filed for divorce. What matters is what it's worth at the time you're getting divorced. One big exception to that is if you're dealing with an issue regarding marital waste, which we'll talk about later. So let's say, for example, where we have the house that is titled only in your spouse's name. If your spouse decides to be really sneaky and thinks that they're going to pull a fast one on you, and they sign the title for the house over to their brother for $5, that's not legitimate, right? The court's going to look at that and say, well, no, we're not going to do that. And so in that case, they would value the property as of the date it was transferred, and you'd have to have someone go back and look at it. And if it wasn't set aside as a fraudulent transfer, the court would then be saying, okay, when you signed this property over to your brother, what was it worth? And that would be the value the court would use for purposes of determining the marital value of that asset. Oh, and quick tip, the value is not going to be the $5 purchase price in that crazy scenario, right? The court's going to see through that the home probably wasn't actually worth $5 when it was sold. Okay, so the Colorado statutes that matter here, one of them is 1410-112. That's the statute that addresses what a separation agreement is. A separation agreement, in a nutshell, is the property agreement that two parties might reach. So while you're going through a divorce, if the two of you decide, here's what we're going to do, we're going to sell the house, we're each going to get this percentage out of it, and then we're going to each keep our own retirement accounts. I'm going to pay you to balance out the artwork that I'm keeping. If you have an agreement that says, here's what we want to happen with our property, we call that a separation agreement. 1410-113 is the statute that addresses disposition of property. That's where we get the language about dividing the marital estate, um, setting aside separate property to each spouse. So that's the statute that gives us the guidance on what the court's job is to divide property. It's important to note that in that statute, it's very clear that when dividing the property, the court can't do that based on marital misconduct or fault. So we'll talk a little bit more about this issue as well when we get to what factors the court does consider. But it's important to know that in general, the fact that someone had an affair, the fact that somebody basically checked out and wasn't being a help to the marriage at all anymore, the fact that someone has a drug problem, those issues in and of themselves cannot be used to decide how to divide the property. So marital misconduct is not an issue. We are a no-fault divorce state. Rule 16.2 is the rule that talks about the fiduciary duty you each have to one another. That's also where you get the language about what documents you have to disclose to each other. And as part of that, in case you're thinking, well, they'll never find my account in the Caymans, or they'll never find out about this property I own with my brother in Florida. If you fail to disclose something and it's material and your former spouse finds out about it, they can reopen the divorce proceedings up to 5 years later. If they do that, it doesn't mean you're married again. It just means the court has to go back and redo the property division in light of whatever asset you were hiding. I should note, we didn't include here the statutes related to marital agreements. That's like a whole separate webinar that we do. But if you have or are forming a marital agreement or think you did, that would be the prenuptial agreement type world. There's a whole other set of statutes that govern how those are enforceable and what we do with them. All right, so the factors that the court will look at when it's deciding how to divide the marital property. So at this point, we're assuming the court has already set aside the separate property, and now it's looking at just the marital property. So the statute says the court has to consider all relevant factors. And then it has a list, which we're going to go through, of the ones that the legislature believes are usually relevant, but that's not that list is not dispositive, right? It's not an exclusive list. So if there are factors in your case that don't fit one of these categories we're about to discuss, that's okay. As long as you're not talking marital fault, you can still look at those other factors. One of them is the contribution by each spouse to the acquisition of that asset. So the court will consider, who's the person who actually found the house and bought the house and decorated the house and put down the original down payment and redid all the flooring, and who was really involved in all of that. The court also considers the value of each spouse's separate property. One place where that is most often relevant is if you have a scenario where one party has like $1 million in assets that's separate and the other has none. The court might think it's fair to divide the marital estate a little bit off 50-50, right? And give the spouse who has no other property a little bit more of the marital property. The court will also consider the economic circumstances of each spouse at the time of the decree. And as part of that, if one spouse is going to be the obvious primary caretaker of the children, sometimes that will affect the courts, or can affect the court's analysis of who should keep the house. If it means that the kids get to stay in the house that they're used to, the court will try to find a way to make that happen. And then lastly, the court will also look at the increases and decreases in value of separate property, including whether any of that property was depleted or used up for marital purposes. So if you used your premarital assets, your separate funds, to fix up the house the two of you are living in together, or to pay off the other spouse's student loans or something like that, the court can consider that when it's deciding what's fair. All right, when we're determining value, some of the things the court looks at are those initial disclosures, right? The bank statements, the credit card statements that we've already talked about. Also the sworn financial statements, because on those documents, you'll be listing what you think your property is worth. The court can also look at the other discovery, if there are depositions, if there are documents obtained by subpoena. The party's testimony can also be essential to determining value. So for example, if you own a house, you are allowed and qualified to testify about what you think your house is worth. right? If your spouse decides to hire a real estate appraiser to appraise the house, fine. It's not necessarily the right answer, right? So if the appraiser comes in and says, I think this house is worth $1 million, and you come in and say, that's insane. We just found out last month that the foundation is totally messed up. The plumbing all needs to be redone. There's no way anyone will buy this house for $1 million. And your testimony is relevant and helps the court decide. Your testimony can also be used to value a business if it's a closely held business. Again, an expert can also be retained to talk about that stuff, but your voice has a place in this as well. And then lastly, your personal property. If you are an expert on what we had a case with Beanie Babies, right? If you're an expert on what these Beanie Babies are worth in the market and you want to talk about their value, you can do that. We will often, though, also use forensic experts if we need someone more qualified than the parties to testify, especially about things like the value of a business. All right, so one of the fun things about Colorado is that once the court has come up with values for everything and it's deciding how to divide them, it is not bound to do so equally. So Colorado is not a community property state, which means the court's job is to decide what is fair, not necessarily dividing everything in half. It is generally accurate, though, that the court will start with an assumption that it's fair to divide things equally, and then put the burden on you all to decide and to argue why an unequal division would be more fair in your case. And again, the court, when it's deciding what's equitable, has to consider all relevant factors. All right, so businesses, any interest you have in a business is an asset subject to division. It can sometimes also be a debt, depending on the shape the business is in, but usually we're talking about it in some concept as being an asset. That's true regardless of the size of the business. So if your business is that you have an Etsy account and you sell stuffed animals that you make on the weekend, that is technically a business. It may or may not have any real value, but it is a business that has to be divided in the divorce. If you have shares in a publicly traded company, they're easier to value. If you have a more complex but still closely held family business, you may be needing to hire someone to value that business. It's also important to understand that the value of the business includes things like the tangible assets, right? If your business owns construction equipment or owns a bunch of furniture or computers, right? It can also include, it definitely also includes the debts attached to the business. Those weigh against the assets. But your business value also includes goodwill, any intellectual property that the business may hold. In some cases, the licenses or contracts that it has, right? If you have the right to be the exclusive supplier of something, that has value. So there are a lot of other factors that go into what is the business worth. I think people will often come to us and say, well, the business has no value because I am the business. I'm self-employed. If I stop working, the business is nothing. They're almost always wrong. There's almost always some value to the business, independent of, because you created something, right? And someone else might see value in taking over your business. So when we can't figure out what a good or fair value is for the business, we will often involve a forensic expert to go in, look at the books, and come back with a valuation. All right, I promised we would talk a little bit about marital waste. And I mentioned already that we are a no-fault state, right? So the court can't punish someone in the property division because they were a bad spouse, they were unfaithful, they're a terrible parent, right? Those factors don't affect how we divide the property. But the court can consider economic fault, which we typically describe as marital waste. Some of the most classic examples of that are cashing out the 401k and gambling it away in Las Vegas, or investing it in something really risky. Withdrawing retirement funds to suddenly purchase a very expensive car. Sometimes it's as simple as unexplained cash withdrawals, right? You're looking back over the statements for the last year and noticing that $100,000 has been pulled out in cash and you have no idea where it is. If those things occur, the court can act as though the money is still there. So if your spouse has cashed out the entire 401k and blew it in Vegas, the court can pretend that that 401k still exists and allocate it to your spouse so that the value of that asset gets balanced out by something else that you receive. So you may end up getting more of the other assets, or your spouse may owe you an equalization payment to make up for the fact that they wasted marital funds. All right, we'll briefly address spousal maintenance conceptually because we do other webinars that address this issue, and that's not really the focus of this one. But you should know the concept of spousal maintenance or alimony gets addressed only after the division of property is done. And the reason it's relevant here is the court can decide to make the property division unequal in order to not need to do maintenance, right? So if you have a marriage where one spouse has always been the breadwinner, earns a lot of money, and the other has not really worked ever, but the parties own some rental properties that generate income. The court might decide to give all the rental properties to the spouse who has no income of their own and no realistic way of being gainfully employed for anything other than minimum wage. Because if they give them enough property and it's income producing property, maybe then they don't also need money from their former spouse who's also capable of continuing to work for another 10 years and supporting themselves without those rental properties. So that's just something to consider. All right, retirement accounts, obviously also assets. This gets tricky in a couple of ways. One of which is people think that their pensions aren't really assets yet because they can't see what they're worth and they won't get them unless they work there 20 years or 25 years and maybe they've only been there for 5. They're all still assets. If you contributed to them in any way while you were married, it is a marital asset. As part of the divorce, one of the fancy things we get to do is divide those assets as a tax neutral event. So if someone has a 401k and the court orders or the parties agree that each spouse is going to get half of the 401k, we can basically set up a second 401k for the spouse, the non-employee spouse, and transfer half of the 401k into that. And then what we have is 2 separate 401ks that are each worth half of what the original one was. And that entire transaction can be tax neutral if we follow the right protocols. So there are specific documents and paperwork that we have to execute in order for those things to happen without the IRS wanting its, pound of flesh. It is important to understand that if you then withdraw money from your brand new shiny 401k account, you will be dealing with taxes and penalties for the withdrawal, right? But the act of moving it into a 401k in your name does not trigger any sort of taxable event. The paperwork required to divide these is highly particular and fussy, and so we usually use an expert to draft the transfer documents related to these. At the Harris Law Firm, we have one attorney in-house that will do them for us, but we also will often agree to hire a joint or neutral expert to do that division, and usually it's a flat fee that you pay to have that done. All right. If the two of you cannot agree on how to value your assets or how to divide them, you can go to court. That's your right. Usually that will then involve some sort of battle between experts if you don't agree about the value. If you both agree the house is worth $1 million, you can go to court and just fight over who gets to keep it or how much money you should each get out of it. But if one of you thinks the house is worth $1 million and the other one thinks it's worth $700,000 and you cannot break that tie, the judge is going to have to listen to all the evidence and make that decision for you. And that process can be expensive. It can take a long time. The court dockets are pretty backed up. And so in some counties, we're back to seeing them schedule these divorce hearings about a year out from when the parties first go to court. That's a very long time. And you're also rolling the dice and trusting that a judge is going to understand and agree with your value. If you're dealing with something like your business or an angel investment or something that's a little hard to get your head around, you have to trust that the judge you're presenting this evidence to is going to understand how to value a restricted stock unit in present day sense. You're going to have to trust that your expert is going to do a good job explaining that to the judge. And then you have to hope that the judge agrees with your value and doesn't think that the other party's expert made more sense or was more compelling. Some of us are risk averse and don't like letting a judge just decide for us. So what are the other options? Well, the one that always exists is you can reach an agreement on your own, right? You and the other party can settle, right? You can go to mediation, you can work through your attorneys, you can sit down over the coffee table and just figure it out yourselves and decide what you think feels fair. If you do that, unless it's an incredibly unconscionable agreement, unless it's something where it's very clearly lopsided in a way that doesn't make sense, or there was clearly some duress or fraud or just bad acts that got you to that agreement, um, the court is going to sanction whatever agreement you guys make because the judge is going to trust that you know better than the judge does what your assets are worth and what is a fair way to divide them. In order to successfully get to the division of property without involving a judge, one of the best tips that we can give you is don't focus so much on winning, right? I like to tell my clients that there are some clients that come in, I call them the engineer clients. I don't mean any disrespect to engineers who may be on this call, but it tends to be engineers and a handful of similar people and personalities who get very hung up on wanting to know exactly what everything's worth and making sure that if we're dividing it equally, everybody's getting 50%. Or if we're dividing it 65, 45, wait, that's wrong, 55, 45, that we're getting those percentages exactly right. That's not wrong. It's not inappropriate. It's not necessarily a bad idea to do it that way. But as I was just mentioning, it can get really expensive because the only way to do that is to value everything. And then you're paying a lot of money to figure out what things are worth. Family law is, as much as this makes people crazy, it's not really designed to pick a winner and a loser or to decide who's right and wrong. So I sometimes get potential clients that will ask me what my success rate is or my win rate is in court. And that's for district attorneys and public defenders, that's a question they can answer, right? They know how many cases they won. We don't have that the same way because if we go to court and let's say my client really wants to keep the house, that is her primary focus. She wants to keep the house. And the judge ultimately decides it's not possible. For whatever reason in this case, you guys can't afford this house. I'm going to order that the house gets sold, but I'm going to give wife 70% of the estate and husband 30%. Is that a win or a loss? My client got a good result on an objective level, but she didn't get what she wanted, which was the house. It's not a bad result, but it's also not really what she wanted, right? So that's a hard thing that people have to understand when they're trusting a judge to make these decisions for them. Again, remember, it's a no-fault divorce state. So the fact that somebody cheated on you isn't something the court's even going to listen to when they're dealing with things like property division. The property has to be divided equitably. That has nothing to do with which one of you is nicer or more likable. And so instead of focusing on winning, it's often a good idea to focus on sort of planning for your own future, right? Take charge of what your life is going to look like 5 and 10 and 20 years from now, and put together a good plan for what you reasonably need in order to support yourself going forward. That's a healthier way to deal with getting through the property division. Things you should avoid. One is hiding assets or intentionally undervaluing them. You may think that you're somehow getting ahead of the game, they're never going to find this asset. But if they do, not only is it now going to be included, but you've lost your credibility with the court, and it's very likely the court's going to start wondering what else you're hiding. And that's not a good position to be in. Similarly, don't withhold documents, don't withhold information, right? Be upfront about this stuff. Judges do not like it when we fight about the fight. They don't like when we play these kinds of games. So being forthcoming with one another is always a good idea. Try to avoid discussing your case on social media. I cringe because this is what I do for a living when I see people posting things about their divorce, about their new parenting plans. It's just generally a bad idea. The fact that it's on social media doesn't mean it can't be used against you. I've also got great examples of people that will do things like post all of their vacation photos for some crazy expensive vacation they took while the divorce was pending, while they're claiming they don't have enough money to pay their own attorney's fees, or they can't afford to pay the other party support while the case is pending, but they just took their new significant other to China for 2 weeks, right? Don't make those dumb decisions. First of all, don't take your new significant other to China while you're in the middle of a divorce. But if you do, definitely don't brag about it on social media. Also, just disparaging your spouse, not a great idea, especially if you have kids involved for 1,000 other reasons. It doesn't play well with the court. They don't like to see it. And in the case of kids, it's also very damaging to them. And that's a whole separate series of webinars that we do about ways to not mess up your kids while you're going through a divorce. Some of the negotiation tips that we have, one of them is be willing to concede issues that don't matter much to you, but are a major issue for your partner. right? Um, a good example of this, as much as I hate to say it, are pets, right? If your spouse has a cat that they are really attached to, or a dog that is their best friend, and you know that that's really important to them, yes, on some level you can use that as leverage, but it's also incredibly useful in some of these cases to concede early on. Yes, I'm not gonna fight you about this dog. I will let you have the dog. I love the dog. It's the best dog that ever lived, but I also understand that you need the dog more than I do. Maybe the dog even likes you more than it likes me. And so I will concede that you can have the pet, and let's just not even make that an issue. Partial agreements are better than nothing, right? If you can't resolve everything, but you can at least decide what you're going to do with the house, you can at least agree you're going to sell the house so you can start getting it listed and marketable and all those things. That's better than no agreement at all. So don't feel defeated if you go to mediation and you only get agreements on a couple of things. It's also a great idea to start with less controversial issues to build some trust and momentum, right? If you think the two of you are going to agree that it makes sense to sell the house, and you think you're going to agree on using the same realtor you bought the house with because you really like that guy, start there, right? It's something that will make it feel like you're making progress and you've got agreement on something before you move on to something that might be more difficult to resolve, like what you're going to do with the retirement accounts, who's going to have to pay back the credit card debt, whatever else is going to be more contentious. And then the best advice I can give you is stay focused on your ultimate goals. The more you can think of this as you building the next chapter of your life and less about fighting over what happened for the last 5 or 10 or 20 years, the better, right? Your focus should be, what do I need in order to move forward and be a successful human being with as little hangover from this process as possible? If you get too hung up on, it doesn't feel fair that we should have to split this asset equally because you never even helped me, pick it out, and like, why should you if you get too hung up on the back and forth about trying to dissect your marriage, you're going to lose sight of what's really important. And on top of that, you're probably going to waste a lot of the money that you could be investing in going to visit this place with the beautiful view on your screen, because you're going to be paying it to someone like me, and that's no fun. Or even worse, you may be paying it to your soon to be former spouse's attorney, and that's even more frustrating for many people, right? So the more you can keep your eye on the prize, so to speak, and remind yourself constantly that there's a light at the end of this, and your goal is trying to get the best deal put together for your next chapter, the better. And then as a final reminder, my boss always likes to tell everyone, you will get through this. It's not fun. I have yet to meet someone, I've been doing this a long time. I have yet to meet someone who before, during, or after said, this is a really fun process. I really like going through a divorce. I think I should do it again. Nobody says that, but you will get through it. There is another side. And hopefully when you go through this, and if you keep your eye focused on what you actually want, and you stay calm and you do your best to focus on the future and not the past, you'll get through it and be able to keep moving forward. So I promised some additional resources. 3 of the places we like to look. One of them is you can see the actual Colorado statutes that apply. This is all of the Colorado revised statutes. So it's every law in the state of Colorado. Title 14, and specifically 1410, is where most of the family law laws live. And those are all available at that link. The second link on here is the Colorado Courts website. That website is invaluable, especially if you're trying to do this yourself, or you've never done this before, and even working with a lawyer, you want a better understanding of the process. The Colorado Courts website has a bunch of forms, which if you're doing this yourself, you can use to move your divorce case through the process. It also has instructions. And for some of my clients, I will send them to read the instructions for this stuff, even if I'm doing it for them, because it is very nicely laid out in terms of what gets filed when, right? If you're initiating a divorce, what do you have to put together? If you're doing your financial disclosures, what documents do you need to gather? So that's a really great website too, to help kind of understand the process. And then lastly, obviously, please do consider visiting our website. We have a lot of information. The webinars like this one get saved up to our website so you can view them whether you were here or not. We also have blog articles, links to other resources, referrals for mediators and therapists and all kinds of people that can help you through this process. So that's a good place to visit as well. All right, and we left in just about 15 minutes for questions.
Perfect. Thank you so much, Katie. All right, we have quite a few questions, so let's get into it. The first one is my ex wants to revisit already divided property. We're now going to arbitration. What can I do?
So I guess that will depend on what already divided means. If by already divided you mean we sat like we met at the house together over the weekend and we each took what we wanted, and now they're saying they want some of the stuff they left behind, there's not really much you can do about it, right? You don't have an actual signed agreement on anything. You don't have a court order on anything. So in that case, you haven't actually divided the property legally yet. If you've already divided the property and the court said, this is the right answer, so ordered, right? You get these assets and they get those assets, and there weren't any failures to disclose things or anything like that, then really it shouldn't move forward, right? It should be done and over. So that's kind of a harder question, and I would strongly recommend you talk with an attorney to get specific advice about what you can do there, because where you are in the process matters a lot, and what options you might have will vary depending on what's happened so far.
Great, thank you. Okay, here's an interesting one. How about solar panels on a house? Can I make an argument for how it adds value and therefore the loan should not be listed as a debt?
Sorry about that. All of a sudden I did something with my mouse, and so now it's not where it was. So I'm just gonna fix that. Okay, solar panels, yes. So functionally, solar panels are gonna be a lot like any other encumbered asset, right? It is an asset. The solar powers have value. They are also encumbered by a debt, just like a house with a mortgage on it or a vehicle that you buy with a loan, right? Unless you plunk down your cash for the vehicle outright and walk away with free and clear title, you're probably buying your vehicle over time, right? It's exactly the same concept. So what they'll do in that case is you have to account for both the debt and the asset. So let's say the solar panels are worth $10,000 and you still have $7,500 that you owe on them. The person who's getting them has a net $2,500 asset, give or take. And you should definitely make sure that whoever gets the panels is also responsible for the debt, right? Those two things should stay together.
That makes sense. All right. I'm in the early days of divorce. We have a house that was purchased by my mom who transferred money to my bank account. The house is in my name and I am the only one on the loan. Will this be brought into the marital property?
Based exactly on what Izzy just read me, that sounds like a piece of property that's going to be treated as separate property. If, however, when you acquired it from your mom, or she bought it for you, or whatever that was, it was worth, say, $400,000, and now the market has gone crazy and it's worth 5.5, the increase in value would be considered marital. Now, that doesn't mean your partner would have any way to take the house from you. If it's truly your separate property, you keep the house, but you might have to sort of buy them out of the increase in value, which can be accomplished with an equalization payment, with letting them keep more of a different marital asset, that sort of thing. And it will depend on the circumstances. There are some situations where, even with the facts you described, the other party may have contribution arguments. Marital funds are being used to upgrade it, to maintain it. But generally, what you've described is the classic example of separate property.
Great, thank you. Um, how are things divided if you're common law or a partition action?
So if you're common law married, you are married, period, end. All right, common law describes how you get married. It doesn't address what your rights are. Once you get married, whether you do it by going to the courthouse and standing in front of a judge, or you get married in a church and sign your marriage certificate on the way out, or you do it via common law. In Colorado, there are lots of different ways you can get married, but any of those that result in marriage form a marriage, and the marriages are all the same once they're formed. So everything we just talked about applies exactly the same if it was common law versus if you married in some other way. A partition action is typically something we do when we have non-married parties trying to divide up property. So that could be a situation where the two of you have been living together for 10 years, but you are not married, right? But you own a home together and want to divide it. Or in the example someone just gave us, if mom was also on that piece of property. So we have cases where maybe the party's credit wasn't great, and so one of their parents co-signed on the house, and now the house is owned by a parent and the two parties. In some of those cases, we have to do a partition action. It's a separate civil action that determines who owns property when the parties are not married. And they're typically in partition actions, they're dividing based on an agreement. If there was an agreement that said, when we invest in this property together, we agree this is how we'll divide it if we ever don't want to own it together anymore. If not, it's typically divided based on your contribution to the property. And that obviously takes into consideration down payments, upkeep costs, improvements, all that kind of stuff.
Awesome. Okay. Are military retirements and VA disability payments considered marital property? And if so, how are they treated during a divorce?
That is a very loaded question. The military has its own rules regarding how some of those things work. Retirement assets, yes, they are. If they were earned during the marriage, they will be marital. And so, by way of example, if somebody puts in their service and they qualify and start receiving a pension, for example, and then they get married, only the part that actually pays out during the marriage counts as marital property. So if you get a check from the VA for $2,000 and you put it in your bank account, that $2,000 is marital, but the rest of the account is not because you earned it before you got married. If you're married for 10 years of a total 30 years of service, only the 10 years you were married has any marital value to it. And so there's a lot of different ways that we then address how to divide or share that marital portion of the retirement benefits. Disability benefits get a little more complicated. They're not generally considered a piece of property, and when and how they factor into income gets messy. So if you have those issues in your case, definitely talk with an attorney and make sure it's one who understands military issues. I will also say that on the military piece, the US military has actually done a nice job of putting out some publications that help answer this. So if you spend a little bit of time Googling, uh, you know, spousal rights for military spouse rights in divorce kind of stuff, make sure you're on the actual US military site and not a third party site, but there's some really helpful resources there.
Great. Thank you, Katie. All right. How about one more? Here we go. My husband received an inheritance a few years ago and put the money in a high interest savings account in his name only. Over half the funds in the account have been used. We are now divorcing, and I was wondering if I have any claim to part of the interest that account accrued. I understand the initial amount is his property.
So in that scenario, I do better understanding these things with numbers. Let's say that the person received $500,000 and the current value of the account is only 400,000 because they spent a bunch of it. And yes, what was left earned interest, but they have spent down what was there. It is probably not going to have any marital value because it is now worth less than what it was when it was inherited. So the account itself has not actually grown. If they inherited 500,000 and it grew to say 700,000 because it was a high yield investment, and then they went and spent 100 of that gain, there would still be marital gain in the sense that you'd still have 100,000 left, right? That would be marital property above the original 500. For most of those assets, they're doing a pretty simple, straightforward analysis of what was it worth the day they inherited versus what's it worth now. And if there's any current increase, that gap is marital. But in the situation you've described, there might be some marital waste arguments there. It gets tricky because technically they're wasting separate property, not marital property. But if there's enough at stake where you're also saying, this account had grown by $300,000 and there was $300,000 of marital assets in there the day we filed, and then they cashed out the whole account and blew it in Vegas, there may be a marital waste argument there for the portion of the increase in value that went away.
All right, great. Well, I think we have run out of time for more questions. Sorry, everybody. But Katie, any final words to leave us with tonight?
The only other thing I wanted to mention that Izzy usually gets to at the end here too is just a plug to, if you are in a situation where you're thinking you either are filing for divorce or your other party is about to, or someone already has, it is a really good idea to talk to a lawyer, even if you want your process to proceed without lawyers involved, just to make sure that you know what your rights and options are. Our firm does a pretty extensive consultation with people. We'll spend about an hour letting you talk with one of our attorneys and explaining your situation and getting some general guidance on what you might need to know. And because you all attended tonight, you, I believe, get that consultation for free. So definitely worth thinking about if you don't know what you're doing in your divorce case.
Absolutely. Thank you, Katie. We definitely urge you to call our offices. The number's there on the screen. It's also there in the chat. Or you can just give us a Google and give us a call and set up that free consultation because every case is different, as we've kind of seen in these question and answer period here. Every case is a little bit different. Every situation is a little bit different, and we want to be sure that we can help you out with your specific case. So give us a call. Make sure to mention the code WISER together or just the webinar in general, and they'll be able to set you up with that free consultation. And with that, we wish you peace. And we hope to see you at another Wiser Together webinar. Have an excellent Wednesday, everybody.